It's 2 minutes after 7. I'll call the meeting to order. It's a meeting of the Town of Norton Zoning Board of Appeals. We have a number of items on the agenda tonight, and we're going to do a little agenda swapping in a moment. But first of all, this meeting is being held pursuant to the emergency orders of the Commonwealth of Massachusetts and the Town of Norton concerning the COVID-19 emergency. It's being held by remote means, and we've provided access to participants and reasonable access to the public who want to join by video and or audio means. And under that rubric, I'm Tom Noel. I'm the chair of the Zoning Board of Appeals. With us tonight is Alan Hooley. Do we have Jim Tenore with us? I don't see Jim. I see also Mr. David Wren with us. Mr. Hooley, Mr. Wren, and I will sit on these matters tonight. Mr. Tenore had communicated, I think earlier today, to Paul and Nicole anyway, that he might have to miss tonight due to his unexpected work assignment. If Mr. Tenore joins us, Paul, please let us know, Paul or Nicole.
I'm texting him.
That's fine. But why don't we get started? Just for purposes of announcing the schedule, we're going to swap a couple of things on the agenda. We're going to start with 157 Mansfield Ave. Then after that, however, at 7:05 is listed 195 Mansfield Ave, comprehensive Chapter 40B permit. I'm going to hold that until the end, and we've notified those participants. And assuming we get to 7:15, we'll start One Great Woods Circle at 7:15 or beyond, and then move to 165 Taunton Ave at 7:20 or as soon after 7:20 as we can. And we'll hold the 240Bs on the agenda tonight for the remaining items in the meeting. And I'll note up front, if anyone's here for 253 Mansfield Ave, 40B comprehensive permit, Paul, correct me if I'm wrong, but they've requested a continuance again to the next meeting because of uncertainty in their plans?
Correct.
Thank you. And we'll get to that in due course and continue it. But first, let's get to the application, an appeal of the building commissioner's decision. The property address is 157 Mansfield Ave. The applicant owner, Norton Mobile Home Park, and I believe the technical name is the Daniel F. Coughlin Trust or Daniel Coughlin Trustee, and John Sullivan, Norton Mobile Home Estate Realty Trust. Who is here to speak for the applicant of 157 Mansfield Ave?
I'm John Sullivan, and just to let you know, the entity name is actually Norton Mobile Home Estates Realty Trust. And Daniel Coughlin passed away a number of years ago, and I've been either getting or not getting mail because it's been going to his former address. And also I have with me Rob Krause, an attorney from Plymouth, Mass, who will identify himself if he has a chance to speak. He's among many other things, he's been the liaison for the Mass Mobile Home Association for probably close to 20 years, as well as very knowledgeable within this field. But hopefully we won't really need to...
Good evening, Mr. Chairman and members.
Mm-hmm. Yes, hi, Mr. Krause. Mr.
Yeah, I don't want to...
Mr. Sullivan, what is your role?
No, I'm the trustee of the park.
Okay.
So my father and Dan and the partners, they bought the park back in 1977. And the park appears, from what I can tell, has existed since at least the 1940s. And like most mobile home parks, originally started as a campground, and then evolved over time to become a mobile home park. I'm normally I'm a developer and a custom home builder, Actually, around 30 years ago, I developed parts of Spruce Tree Village off of Richardson Ave and developed Todd Drive Extension in Norton. So I've been floating around under the radar for quite some time, it seems.
Okay.
And then I noticed in April I had my landscaper approach me and asked if he could move a coach in on the park there, on an empty lot there. And I just before I forget, just let you know, I'm on the Conservation Commission in my town of Dover. I've been there for 14 years. I've been the chair for 7, so I appreciate your volunteering, your time and effort, more than you can imagine. So I have a pretty extensive development background. And in April, typically, a person asked me if he could move a mobile home into the park on an empty lot. And in the past, that had never been an issue. I notified some of the neighbors, and the caveat I gave them, I said that there would be no occupancy whatsoever until all the appropriate permits were pulled. Typically, what we've done historically is if we have a used coach come in, then they apply to the building department for electrical and plumbing permits to do the hookups there. If we're putting in a new pad, we apply for a full-on building permit. That's the way it's been for many, many years, and I noticed that when you had 250 Mansfield Ave in front of you, they expressed a similar surprise that normally the park is, as long as we kept in the units and communicated with the correct inspectors, there was never a zoning issue that came up. And in Chris's circumstances, he got a phone call from a neighbor saying that this was happening. There's no subterfuge on my part because I notified the neighbors. And he informed me that he believed that the grandfathering, in essence, the non-conforming use that the park is under, extended to the individual units within the park. And
Okay. We'll get to that by talking to Mr. Carmichael in a minute.
okay,
But you're going to present along with Mr. Kraus?
yes.
Okay. That's
And
fine.
Can I say something, Mr. Chairman?
Go ahead briefly, because we haven't gotten to the letter yet. Go ahead.
My client, Mr. Sullivan, and I have spoken with Paul, and we also filed a variance, a general variance with respect to the matter that's addressed by Mr. Carmichael as the zoning enforcement officer. That's not on the agenda tonight, which might supersede and circumvent the necessity of the board to consider the letter of April 27, 2020 of the the zoning enforcement officer, just so that you know.
I'd heard that a second application was in the wings, but I didn't know it has it been filed, Mr. DiGiuseppe? Paul?
Yeah, it has been filed. Mr. Kraus's letter, we reviewed it and we've submitted it to town council, whose response was the letter itself wasn't clear what exactly they were seeking variances to. I relayed that back to Mr. Kraus, and we have not yet received that the response. So at this point, we can't consider it a completed application because we wouldn't know at this point how to notice it. So
Okay, so that's going on between the parties. That's fine. No, wait, Mr. Sullivan, hold on. These video meetings aren't perfect. Neither are we. But just try to hold on until I recognize an individual. I have the Hollywood squares here. I have about 20 squares of people.
Mm-hmm.
So if you just want to hold up your hand, that might be a little easier for everybody. So there's disagreement as to the second application. I understand that. Let me ask this, Mr. Kraus, without prejudice to anything further. Does the applicant want us to proceed with this appeal of the building commissioner's decision, or does the applicant wish to go with the second application, whatever that may be?
I will defer to my client, Mr. Sullivan, but we think that if the board addresses this on a larger scale in respect to the Shirley Wayside law case that we have shared multiple times, that it would obviate the need to address the particulars of Mr. Carmichael's decision. Shirley Wayside is a Supreme Judicial Court case that basically held that the nonconformity in mobile home parks reflects the entire park. There are no individual lots in a mobile home park. We think this is nothing with respect to Mr. Carmichael.
Understood. Hold on, please. Sorry to interrupt, Mr. Kraus. Somebody who is tuned in has background noise going on, whether it's a radio or TV or other people in the room. Please mute your microphones if you're not speaking on this matter. If you're not expecting to speak in the next few minutes, please mute your microphones so that we don't get the background noise. I'm sorry, Mr. Kraus. Go ahead.
Not a problem.
Except
Thank you, Mr.
that
Chairman.
I'd like to proceed a little differently. I understand you're here to speak to that issue, but let's get to that in a minute if that's okay. If your intent is to proceed with this appeal, we'll go from there.
It is obviously up to my client how we proceed. John, would you like to wait until the variance is heard first, and then if that is decided in a certain way, that would obviate the need for a consideration of Mr. Carmichael's April 2020 decision? Completely up to you, John.
Well, I was under the impression that we're going to review Mr. Carmichael's decision in light of whether granting a variance would not be detrimental to the neighborhood, and to get a sense of, as we discussed with the board, if that seemed a likelihood, then we would go with that, and if that seemed unlikely, then we would come in under the second variance later on. But I think some of the things may be clear enough that if we open up some discussion to that, we may that a variance may be the normal thing to grant for the installation of a mobile home on an existing pad.
So I think I hear that you're going with this application, this appeal of the building commissioner's decision.
Correct.
Okay, so we'll proceed accordingly tonight.
Mm-hmm.
So the application is describes the present use of premises as a manufactured housing community, extent of alteration, replacement of manufactured homes. It's here as an appeal of the building inspector's decision of, I think, April 27. Mr. Carmichael is with us tonight, but basically, I'll recap the letter as best I can and ask Mr. Carmichael to correct me or to comment further first. A letter of April 27 addressed to Daniel Coughlin, trustee, and to John Sullivan of the Norton Mobile Home Estate Realty Trust, Dover, Mass. Conversation between Mr. Sullivan and myself by phone on April 24. Mr. Carmichael was notified that the park, if I can just call it the park, was planning to install a mobile home. During the phone conversation, Mr. Sullivan confirmed that it affected lot 38 on 157 Manfield Ave, and that a new manufactured home was due to be installed on that Sunday morning. Mr. Carmichael issued a letter stating that pursuant to the bylaw, to replace an existing mobile home for a new home must be the same size, sit in the existing footprint, that any deviations from this would need a finding from the Norton Zoning Board of Appeals under 1.5e of the bylaws, and that under Article 1.5c, a non-conforming use that is discontinued for a period of 24 months or more, if a non-conforming use remains unused for 24 months, such use or building shall be deemed to have been abandoned, and no resumption of the non-conforming status shall be permitted. That is cited in Mr. Carmichael's letter. Therefore, apparently, Mr. Carmichael's letter says the lot has been vacant for 2 decades, more than 2 decades. That's the basis of the letter. So that just frames the issues for tonight. Mr. Carmichael, was there anything first? I'll ask you. I believe I summarized your letter accurately. Would you like to add anything else, Mr. Carmichael, as building commissioner at this time?
As the zoning enforcement officer, you touched upon all the zoning issues. There were also numerous building issues that I addressed in that letter. I understand we're not going to discuss those tonight.
Well, the letter goes on to say that there were apparently no permits pulled for this addition of this home, installation of the home, whatever. And that's noted in the letter as well. And you're right, that's not, I guess, under our purview. That's an additional, well, it is if that's being appealed, I suppose. Mr. Carmichael, were there any applications for permit at the time as of that?
No, Mr. Sullivan was trying to slide that in under the radar on a weekend, and I stopped him. And he didn't have any permits or applications on site or filed. He has proceeded like this in the past. So I caught him again, and I've asked him to stop this, and I included that in the letter as well. This needs to be done.
Mr. Sullivan, I understand you want to respond to that. I'll give you a chance in a minute, if that's okay.
Okay.
Mr. Carmichael, no permit applications were on file then for this particular installation?
Absolutely not.
Okay. So, and it's the town's position under your office that building permits would be required for an installation of a mobile home or manufactured home on a lot.
Any work as required in 780 CMR requires a permit prior to the commencement of work.
Okay, Mr. Carmichael, I'm sorry to interrupt. Was there a slab in position, a concrete laying foundation or slab at the time?
Slab has been there since, as far as I can tell, for more than 30 years.
Okay. To your understanding, though, no home had existed on lot 38?
I went out to investigate. When I received the anonymous tip, I went out and talked to the neighbors, and they confirmed that no trailer or mobile home had been on that site in more than 2 decades.
Okay. Thank you. Now, Mr. Sullivan, I'll give you a chance to respond to that, but factually, is what Mr. Carmichael said about the lack of permits accurate for this installation on lot 38?
Under his purview, it is correct. Previous building inspectors had been had viewed that a little differently. And I have no objection to filing necessary permits. I've been willing to speak to Mr. Carmichael to that effect.
Okay, so there were no permits applied for this installation on lot 38, correct?
They were planning to be applied for that Monday or Tuesday. The tenant had a situation where he needed to bid on this coach and have a place to put it very quickly, and I no good deed goes unpunished, so I relented. But historically, we have pulled permits after coaches have arrived because we clearly want to have the proper permits in place and an occupancy permit and so forth. And that was my agreement with them. I would like to just interject as well. Number one, it's been around 12 years, as opposed to 20 years according to the neighbors. Most of the neighbors have not been here that long. Number two, this is the only coach we have moved in since for a number of years, certainly since before Mr. Carmichael has been on. And I'm more than happy to talk to him, but this idea that I would try to slide by things, I don't operate for it. And I would be more than happy to confer with him to make sure that we're aligned in terms of what it is he's looking for when it comes to a mobile home installation there.
Okay, well, I think
as I know
that's going to be resolved tonight, I guess. Or
I hope so, because I think we may have gotten off on the wrong foot, but we haven't really just. I think I've spoken to Mr. Carmichael twice, and it's been all this year, so I'm not sure where this has come from.
Okay, well, disregarding past history, whatever it was, there were no permits or applications for this installation on lot 38 at the time of Mr. Carmichael's letter. We agree there, right? Okay. And by the way, members of the board, if you have questions of Mr. Carmichael or of the applicant or applicant's counsel, please feel free to jump in here as well. I'm just trying to establish the baseline of facts. there was did you say there had been no home there for, did you say 12 years?
From looking at Google Earth and my records, it looks like it was around 2008 or 2009 when that coach was moved out.
Okay. And there is a slab there. Are there utilities coming from the slab?
Yes, and the slab was never abandoned. There's water there that has heat tape on it. There's an electrical meter there. There was never any intention to abandon it, and we'd never encountered any sort of zoning issue historically.
Okay. Mr. Hummel, I'm sorry, Mr. Kraus, you had your hand raised. Thank you.
Yeah, thank you, Mr. Chairman. I'll be brief because I know you have a long agenda. And again, no offense to Mr. Carmichael, he's doing his job, and we're trying to cooperate. So you have basically two distinct issues articulated in the April 27, 2020 letter. One, the nonconformity discontinuance because of time, and then the permit application. As John indicated, he's happy, we're happy to do anything we have to do under HUD standards, which controls manufactured housing. With respect to the nonconformity, which I think is probably more important to the board, Shirley Way site is a really important case for the board to consider, and we've shared it with Paul and town council. And this is one that, we have some particular familiarity with because we do a lot of manufactured housing. And it's and I'll quote from Joe Kelleher's letter, which was accompanying the appeal of May 25th, 2020. I should tell you that Joe just got appointed to the housing court bench. So now he's a housing court judge. So that happened about 30 days ago. On the second page, he writes, Shirley is a Supreme Judicial Court case that is directly on point in this matter. Shirley stands for the legal standard that for manufactured homes, the entire park must be considered in the context of pre-existing nonconformity status and not individual sites within the park. And that's at page 470 of the decision. Literally, the nonconformity deals with the outline of the park. There are no individual lots within a manufactured home. There's a concept that somebody has a lot, but there's no legal significance to it. So, having said that, and extrapolating from Shirley, which I think is directly on point, we don't believe that there's a 2-year loss of rights to replace the manufactured home. In fact, we believe that we have a right to replace a home. We're not trying to expand the park. There are 56 units. We're not trying to do anything that is not within the conformity of the permit from the Board of Health. Yes, we will apply for the permits. We're constrained by that. We want to work with Mr. Carmichael. Maybe we got off to the wrong foot, but that is not a 40A zoning legal standard. Our position is that we have a right to replace the home. We will apply for the permits. We will comply with the HUD standards because it's not a stick-built home. HUD controls the standards because of there's a great distinction between 76, before 1976 and after 1976. I won't get into it. It's too long. And I've been involved in this since I was in the legislature and helped write the 93 amendments when it comes to manufactured housing.
Okay, Mr. Kraus.
Let me just finish, Mr. Chairman.
Well, there's a lot of history you're presenting that I'm not sure is important to what we need to do next. Can you wrap up the history?
I'll gladly wrap up. As John indicated, and my client indicated, we appealed the decision of Mr. Carmichael, and then we filed a general variance, which we've been working with Paul, who is terrific. We haven't gotten it in, but the concept is that in the general variance that we submitted and have not perfected, we want to address this issue generally so that the board can take this on generally as opposed to the particular decision of Mr. Carmichael. John, I'm sorry.
If I can interrupt Tom just for a quick moment. While that is intellectually correct, what I mentioned earlier is because I have somebody who would love to move move this coach on with the appropriate permit, and he's currently storing it. You have to take it literally off the highway when it was en route with a police escort to put it somewhere else to store it. I wanted to explore on this particular unit the feeling of the board in granting a variance, regardless of what Rob has been saying about the legality here, but in terms of effectuating a home for somebody who is in harm's way right now because he's doing a short-term rental with
Okay, so that's
Subject to getting all the permits, right, John?
Hold on. I understand. That's an unfortunate situation. I'm sorry that the mobile home park is in that situation. But with all due respect, that fact and the fact that Mr. Kelleher is a member of your firm, correct, Mr. Kraus?
Your Honor, Mr. Chairman.
I'm not an honor.
Well, you may not think so, but I do. He's become a judge. He became an associate justice of the housing court about 30 days ago.
Great. He's not going to sit on this case, though. He wrote as a member of your firm previous to this, so that has no bearing on our decision.
No, of course not. Of course not.
Thank you. So, members of the board, a couple of things, just to move this along if I can. We can talk about this, but Paul, do we have anything from town council on this? Mr. Kraus said he had communicated the decision, and I know this has been going on for a couple of months, but do we have anything from Ms. Quessel?
No, she was awaiting the response of what specifically were we seeking a variance to.
Okay.
She does have Mr. Kraus's letter and reference, which goes into a lot of detail about that case.
And I'm sure she's aware of the Shirley case. My question to the board is, do we continue this to get Amy Quessel's town council's assistance and opinion, since it's been she's been mentioned here and the opinion has apparently been sent to her some time ago. I'm not going to jump in as lawyer and interpret the opinion. I certainly understand where Mr. Kraus comes from in citing the opinion, but I certainly understand how the board has treated these matters before. We could discuss it tonight, or we can continue it to allow Amy to give us some advice. Mr. Wren, Mr. Booley, how do you feel? David?
My feeling was, as we were going through this, is that while I'm sure this case is appropriate and whatnot, I'd really like to hear from the other side, if you will, which would be, of course, Amy's perspective. I think we need that. I think we need that second perspective, because otherwise, no disrespect to anybody else here, but I need to hear the other side.
Yeah. Allie?
100%. I'm not a lawyer. I can't tell how the Shirley case applies or does not apply. I would love Amy's opinion, especially if we're looking at this as a whole, as the whole park. We're not just looking at this one mobile home. I don't think anybody's going to be too aggrieved by any of this. I think we really just have to get it right.
Okay. So I'm hearing that you'd like to consult town council, as I agree. I agree with that. My initial reaction is, even if we treat this as a whole, the whole 56 units, if that's what it is, doesn't the nonconformity isn't that still increased with what's being planned there? And doesn't that mean that the increase or change or alteration to a nonconformity under 1.5 means that it has to pass muster under 1.5E, and whether you treat it as an individual lot or not. 1.5E is pretty clear, and as is the 2-year loss of rights provision. That's my concern, but I want to run that by council as well. Mr. Sullivan?
Yes, I just, my initial intention this evening was to actually discuss this in light of 1.5E and Chapter 46A in terms of your ability to grant a variance if something is not viewed as detrimental to the neighborhood, similar to what you did with the double wide replacing a single wide down the street at 250. And even if you didn't make a decision, what I noticed at those other hearings, that there was some confusion about just the where mobile homes are different from conventional zoning. And I was hoping to just break that out very quickly, just so that you could see that you still have the ability, even if you felt that that the 2-year statute was lost, even though but you're looking at a 2-year statute for something that's not a building. It's a mobile home by its nature, and it can't be recorded at the registry. You can't put a mortgage at it.
Well,
we pay an excise tax on it.
I understand, Mr. Sullivan, but I don't think that gets over my concern that even if you treat it as a whole, you're still changing. Make believe it was one big house on the footprint that exists.
Yeah.
If you change the footprint, if you extend the footprint, it's still a change to a pre-existing non-conforming use, if that's what it is.
Mm-hmm.
And right now, mobile home parks are not permitted in town, so this would be an alteration to a pre-existing use. But I'd like to get town council to weigh in on that.
And that's,
I'm not deciding anything tonight.
Oh no, I see that. My point was being more that if we took it as on an individual basis currently, and said we have a pad that's been there, we're looking to put a unit on this pad, and have you grant that variance for that, because it would be, since obviously the pad existed, it wouldn't be detrimental to the neighborhood. You have that ability to overcome what you're perceiving as a 2-year.
That's the regime. That's the regimen that we came under in prior decisions.
Right.
0.5e determination and a variance if it were required, and this is very close to the side yard set line.
Mm-hmm.
So I agree that those are possibilities here, but that's not what's before us. So right now, I think it's appropriate to ask for a continuance to the next meeting and hopefully get town council's assistance on this.
So you see that what's in front of you is for the global basis, as opposed to a request for a response for a variance based on the building inspector's letter.
No, it's an appeal. What you have here is an appeal of the building inspector's decision,
Right.
which incorporates those things. It incorporates 1.5e and 1.5c, whether the non-conforming use or structure, the rights to that lot 38 had expired 10 years ago. So it's all part and parcel of the building inspector's letter. Nothing says you can't apply for a 1.5e finding determination under 1.5e or a variance, but that's not before us right now.
Oh, I thought that that's actually what was in front of us.
The issues may be overlapping, but right now we have the building inspector's decision and your appeal of that. So, Mr. Kraus, is there a reason not to continue this till the next meeting, which is, I think, 4 weeks from now? Aside from the inconvenience to the applicant, which I understand.
It's, Mr. Chairman, with due respect, you're going to seek town council, and that's what your board seems to want. But we have a person in we have a person who wants to site a manufactured home there, who has waited for months. And of course, with the COVID, it's very difficult. And Paul has been cooperative, and we're trying to work with Mr. Carmichael. Is there any way to expedite it other than a 4-week continuance, Mr. Chairman, because of the direness of this person with this manufactured home waiting to have it cited potentially as a result of your decision? That's what we're asking for.
Well, let me put it this way. If we were to turn down this appeal tonight, I assume your next step would be to file a variance or 1.5e determination. So we can move forward tonight and go on the record, but I think members and I want to hear from town council. I know we've had a very busy schedule, unfortunately.
Right.
Partly due to COVID, we continued things, including, I think, this matter. I mean, this has been on our radar since at least May or June, so it's not all. The inconvenience is nobody's fault, perhaps, and I'm
not suggesting.
No, I understand what you're saying, but maybe we all better blame the COVID crisis rather than any of us. And I don't know that I'm going to be available prior to the next meeting, which is when, Paul? Sorry to put you on the spot.
When is that, Paul?
It's October
I'm just checking.
My availability is tight in the next few weeks.
October 14th.
14th, so it is 4 weeks from tonight. I don't know that I'm going to be able to, given my other professional schedule, get another night to this. We also have two 40Bs or maybe one 40B that we've been considering. Members, do you have any other feelings to try to stage another meeting in 2 weeks or 3 weeks?
Mr. Chairman, I personally I don't personally have much of an object. If we wanted to have another meeting, I'm sure I could make it work.
Well, Alan, what's your...
I mean, well, right off the bat, my feeling is if this is such a dire need, which I agree, if he's saying this gentleman's been waiting, why isn't there a variance in front of us then right now to be looking at tonight if it's in such a dire need of time to get this done? I would think that all that would be done by now to be in front of us.
We do have a variance, Mr. Chairman. On August 4th, 2020, we filed a variance, and we set out in great detail what we were seeking. Paul, with respect, sent a request after speaking to council. I haven't spoken to town council.
I understand.
But we have.
I got you. And I'm not trying to cut you off, but we do have several items stacked up here. How about this? David Allen, can you do an additional meeting a week earlier, October 7th? I don't know Amy's schedule, by the way, but hopefully within 3 weeks she can at least get back to us and we can look at this in some, hopefully she can attend, but if she can't, at least she can hopefully get back to us with some writing on this. David Allen, would you be willing to do an interim meeting, an additional meeting October 7th, if we just schedule this matter and with Paul's grace and dignity, hopefully not much else on the 7th. I already have things for the 14th. Take a minute.
I can do October 7th.
Alan?
Yes, no problem.
Thank you.
Mr. Kraus, is that somewhat better? Somewhat better?
And thank you, Mr. Chairman, and thank you through you to your members. We appreciate it. And by then, we will also have the colloquy or whatever the document is that Paul needs. What I would ask is I'd love to be able to speak to town council and maybe shortchange, because what typically happens, as you well know, is council writes an opinion or gives an opinion, then I write an opinion, and everybody. I'd love to have a chance to speak to council about this.
Nothing's stopping that.
So, Chair.
Yeah.
So, Robert, if they do go on October 7th, I need that description of what exactly you need by tomorrow. Because I have to get advert notices out 2 weeks prior to October 7th.
I'll have it to you tomorrow.
That's not going to work unless the applicant wants to file something tomorrow. I didn't think of that.
Yep, no, we can do that.
We'll do it, Paul. Paul.
Chair, they have the application in. We just hadn't been able to notice it because we weren't clear what they were asking for. If we can get that tomorrow, we can get the notice and get that variance on October 7th in addition to the appeal.
Okay, but again, even if the variance doesn't get in tomorrow, it can still be scheduled for another meeting, maybe the 14th even, which would give them another week if they want to change that application. I'm not suggesting everything has to be done on October 7th. I'm just offering an additional meeting for...
It would make sense, Mr. Chairman.
For this decision anyway. And if the application gets filed tomorrow, so be it.
That's very, very much appreciated. I appreciate
very much. Paul, what's your telephone number that I can call you, if you don't mind? Or is that possible?
It's on one of his emails. I don't know if he wants to broadcast that. It's on one of his emails.
Well,
yeah, it's on Paul's email, and if you need to get in touch with town council, we can certainly put you in touch with town council.
Done. Very good. Well, you'll have it by 5 p.m. tomorrow.
Okay.
I just had a question on the...
Mr. Sullivan, go ahead.
Paul, on your agenda item tonight, you mentioned 2 lots, and I was just wondering what the second lot was involved in. Do you know, or does Chris? Do you know, Chris Carmichael?
Oh, it does say in the description on the agenda, seeks to appeal a decision regarding replacement of 2 mobile homes. Right? That's an error, I think.
Lot number 38 was what I wrote the letter on.
Okay.
That's a mistake.
That's just on the agenda, right?
Okay,
It's
I was-
one.
No problem.
I was just, and then
No
I
problem.
actually, so Chris, would I be able to talk to you about other items from this, directly?
You can talk to Mr. Carmichael.
Mr. Sullivan.
I'm sorry, Chris, I didn't.
I
hear
look forward to any conversation with you, Mr. Sullivan.
Absolutely, me too. So
There's no limit. You can talk to Mr. Carmichael or town council anytime. It's just this meeting, we have to continue to the next session.
Very good.
Is there a motion, Mr. Wren or Mr. Booley, to continue this matter, 157 Mansfield Avenue, appeal of the building inspector's decision to October 7, a meeting we just established at 7 p.m.?
I'll make that motion.
I will second it.
I have to take a roll call vote and no further discussion on this. Mr. Booley, how do you vote?
Yes.
Mr. Wren?
Yes.
And I vote yes as well. This hearing is continued to October 7 p.m. Thank you, Mr. Cross, Mr. Sullivan, and
Thank
Mr.
you.
Carmichael as well.
Thank you all.
Okay, thank you.
And we'll contact town council in the meantime.
Okay, good night, folks. Bye-bye.
Okay, as I announced at the beginning, we're going to take up 195 Mansfield Ave and 253 Mansfield Ave a bit later. I'm going to move to 1 Great Woods Circle, which was noted for 715. Property address is 1 Great Woods Circle. Applicant owner, Mr. Osario. Is Mr. Osario with us?
Excuse me, I believe Victor is on. My name is Amanda Langer and I'm with Jacobs Driscoll Engineering.
Okay, are you speaking for the applicant?
I'm going to introduce the project briefly, and then I'm going to let Mr. Rosario take over afterwards.
I see Amanda, Langer. What's
Yes.
Okay, thank you. The plan of record was submitted by your firm. So this is a location of property, 1 Great Woods Circle, formerly known as 32 Smith Street. It is an R40 zone. This is 1 lot at the moment. Present use of premises vacant house. Proposed use of premises 2 single-family homes. And if I can summarize, the applicant is seeking to divide what is now a single lot into 2 separate lots that the applicant would like to build separate residential units upon. 71,901 square feet. I'm sorry, I'm going to ask you actually, Amanda, to describe the total square area now and the total frontage and the intention.
Of course. So currently it is a 71,901 square foot lot, and it has 290.94 feet of frontage along Great Woods Circle. And it also has, I believe, 89.85 square feet of frontage on Smith Street. The applicant is proposing to subdivide the property into 2 separate lots. One of the lots will be conforming. The second lot is going to be shy of about 8,189 square feet to meet the 40,000 required. And it's going to be shy of about a little less than 10 square feet to meet the required frontage along Great Woods Circle. The lot previously was only had frontage on Smith Street, but back in 1987, there was the Great Woods subdivision that was approved, and that is essentially what gave us the frontage along Great Woods Circle now. So we're here today to ask for the relief for that 8,189 square feet of required lot area, and that essentially 10-foot relief of frontage that's required.
10 foot? Oh, yes, it is 10 feet. I'm sorry.
Yeah, it's a little less than 10 feet. It's like,
Yeah, I see it. And there is the additional frontage adjacent to it on Smith Street, I'll note.
it is.
Record as shown on the plan of record. Thank you. If I could stop you there and just ask a question or two. Is there any structure on the lot now?
The structure that was there has been removed. I'm not exactly sure when it was demolished, but it was within the past few years.
Okay, so because the application actually says vacant house, but there's nothing there now.
There's nothing there. No, there was a vacant house on there for quite some time.
Okay.
But it has since been demolished.
Thank you. And have you been, can you take down the plan? Thanks. Have you been before the planning board for an A&R at this point?
No, I don't believe we have. I think we wanted to go forward with you first to make sure that it would be acceptable to the ZBA to allow these reliefs.
Okay. I will, members, if you have any questions, please jump in. I will note that we recently decided an application on 130, I think 3 South Worcester Street, where we had advice from town council that we actually did not have the authority to do what was sought. I don't know if this is parallel to that, but my thought is that we need to look at council's opinion from the last application, or ask council again, is this the same situation as was cited last time or not? And therefore, apologies to the applicant again, but I was going to see if the members wanted to defer this as well to a next meeting, so we can get council's assistance. David, Allen, do you have initial questions though, or comments on my idea?
No, I believe this completely aligns with that last decision, and I didn't take it much farther than that.
Yeah, it felt like deja vu. And that issue, obviously, with that particular finding was rather complex.
It was, and that my point is, I don't recall sitting here, and I don't want to just look at the record right this minute, whether it was frontage and square footage and lot area. I think it was, but I'm not sure. So rather than guessing at comparing apples and oranges, I'd like council to look at this and just ask her, is this the same as we just considered and under your opinion, denied for somebody else? And I think she could probably do that for us fairly efficiently. So my recommendation would be to get that opinion and ask that this be continued, either to the 7th or the 14th, since we have 2 meetings now.
Are you able to tell me the circumstances of the reason why it was denied? Is it because they were asking for both relief of frontage as well as?
Well, again, I believe they were, but the decision we just rendered a couple months ago, we can certainly make that available. We can certainly make the file available to you.
Oh, that'd be great.
Yeah, you can take a look at it at the same time we do. But Paul, did you want to add something to that? I saw you leaning in.
Well, I'll be happy to send along that decision. My recollection on it was that with that case of 133 South Worcester was that they took a conforming lot, and when they subdivided it, they were creating, in that case, I believe, two substandard lots, and that was one of the triggers. We'll have to pull up the decision on that, but that was certainly a factor, was creating a new non-conforming one doesn't exist right now.
Right. Correct. Ms. Langer, if you want to communicate with Paul at the office or me, we can send you that application and decision pretty easily, tomorrow. Is there a motion or feelings of the board? Do you want to try this on October 7 as well? Amy may be part of that meeting anyway.
Make a motion to move this meeting to October 7th.
I'll second that.
Okay, applicant, can you make it back here for October 7th, or would you like a later date to give you a chance to look at, what we're talking about?
I'm certainly available that day. Victor, is that okay with you?
Yeah, that's fine.
Okay, thank you. So there's a motion to continue, no further discussion. I would say that this would be continued to 7:05. I'll have to take a roll call vote because of meeting by remote means. Mr. Booley, how do you vote on the continuance to 7:05 on October 7th?
Yes.
And Mr. Wren, how do you vote?
Yes, also.
And I vote yes as well. Thank you, Ms. Langer and Mr. Rosario. We'll see you in 3 weeks, but certainly communicate with us, Amanda, tomorrow.
Absolutely. I will either call or email Paul tomorrow and get the information.
We'll do a comparison, apples to apples, if we can. So
Definitely.
we just want to do it correctly. And thank you very much for your understanding.
Thank you very much. I appreciate it.
Next on the agenda is the application of 165 Taunton Ave. Daniel Madden of 165 Taunton Ave is the applicant. This is a single-family home. Proposed use of the premises is the same. This is an R60 zone. Total area for the lot is sufficient, 76,000 plus feet. The applicant seeks the addition of a screen porch and deck to the rear of the house. The new deck, however, is 13.3 feet from the side yard property line, and the plan of record is by RIM Engineering, dated, I think it says August 21, 2020, showing the an apparently existing deck 13.3 feet off the side yard setback, the existing house being 25.7 feet, I think, without the deck from the same side yard. So that is in conformance. The house prior to the deck. Mr. Carmichael issued a cease and desist on August 5, 2020. That's also in the file, addressed to Mr. Madden, 165 Taunton Ave. A stop work order, letter written to the current listed owner concerning illegal construction observed at the property on August 5. The work can only resume once proper building, electrical, plumbing permits have been issued, as well as a site visit with the owner and contractor to determine the extent of work that was performed prior to proper permitting. This was not Mr. Carmichael's letter, but by Mr. Is it Lafretti?
Iafredi, he's the local inspector, Mr. Noel.
Iafredi, thank you. I couldn't, I just didn't read the letter correctly. But Mr. Carmichael, you have familiarity with this matter, correct?
Yes, Mr. Iafredi issued the stop work order, and I agree with his letter of stop work and no permits and the requirements for a variance.
And let me just ask, as a matter of fact, is it a fact that there were no applications for work that your department deems would have been necessary as of August 5?
That's correct. No applications or permits were on site prior to them getting a stop work order.
Okay. And is the applicant, Mr. Madden, with us?
Yes, I am.
I see you. Thank you. Daniel's iPad too is how you're reading here, but thank you. Mr. Madden, you're trying to, and apparently have partially constructed a porch adjoining your house?
Yes.
Okay. Can you, first of all, without getting into the the stop work, tell us what you're trying to do.
Okay, we started this back in May, and during the height of the COVID, actually, and knowing town hall was closed, I didn't know we could get a building permit online. So, we progressed with some work, and then when Mr. Iafredi came with my stop work order, I applied that day for the permit applications for the building permit, electrical permit. So that was, I guess, 5 weeks ago, so we've been waiting, and then I had an civil engineer come in, and he was telling me that, as you can see on the plan there, that we were only 13.7 feet from the property line.
I think it's 13.3, actually, if I'm reading it.
13.3, yes.
But the record is what the record is. So you had not had that survey prior to construction?
No, I did not.
Okay. What was done as of August 5? Can you tell me, Mr. Madden?
The deck is complete. The screen porch is maybe 70% complete.
Did you have a contractor working on this?
No, I basically did it with family and friends.
Okay. Are you a contractor, licensed contractor?
No, I am not.
Okay. Again, members, jump in with any questions. I'm just asking a few factual questions. Mr. Carmichael, are the proper applications on file at this point?
Yes, as soon as Mr. Madden got the stop work, he absolutely within hours applied for the application, and he's looking to comply moving forward.
Okay. The side yard setback in this zone is ordinarily 25 feet, I'll note, correct? Yes.
Correct. 5 feet, Mr. Chairman.
And the plan that was done on August 21 shows the deck at 13.3 feet. And as I said, without the deck, the closest point to the house prior to the deck addition was 25.1 feet. So whoever built the house was knowledgeable of the requirements or was within conformance requirements. Members, questions?
Not at this time.
What's the lot
Sorry?
next door? Oh, sorry.
Sorry, David, go ahead.
Yeah, I was going to ask the lot next door. What is that? Is there a home on that lot, or?
Yes, there is.
And that is Mr. Shabbat. I see Mr. Shabbat is in attendance.
Yes.
Mr. Shabbat, could I ask your opinion as to what's gone on here, whether you would oppose this relief if we were to grant relief? You're the adjoining abutting neighbor on that side, correct?
Yes, and thank you, Tom. We have no objection. To be honest, we weren't aware that it was being built too close. We haven't really noticed it. I think being a deck, I don't know what to say other than it's a deck and it doesn't bother us.
Is there a tree line between the properties, perhaps?
There are some trees, and there are only a couple of windows on our house on that side, and there's also a shed that kind of blocks the view. We don't really see it.
Okay. So that's the directly abutting neighbor. Let me ask something else. I'm not sure who can answer. There's another plan submitted with the application. It looks like a sewage or septic plan. Who submitted that, or where did that come from, Mr. Madden? Do you know?
No, on the original plot plan, it shows the septic out front. Maybe that's what it is, but my septic and leaching field are in the front of the property.
This is in the file. I'm just asking, did you submit it for a purpose?
I believe I did. At the time, I thought that's what I had to send in, so.
Okay. Oh, I see. This actually, this septic plan, I'll call it, shows the corner at 15.3 feet. I assume that's an erroneous measurement since the survey plan from RIM Engineering shows 13.3.
That is correct.
Okay. So 13.3 is the survey plan is the plan we go with. Let me ask if anybody else in attendance has any comment in favor of or in opposition to this variance application. For the record, I see none. Mr. Di Giuseppe, do you concur? You don't see anybody
Yes.
here? Okay.
And I don't see anyone through chat or waving their hands, so.
Thank you. That's what I'm trying to confirm. Thanks.
I do have a question.
Yeah, of course. Go ahead.
On the RIM engineering plan, we have the little box that is written deck in it. That is, I assume, what they're building. What is the box behind it that's unlabeled? Is that the part of this addition?
Yeah, that is the three-season room screen porch, yes.
That three-season room butts all the way to the wetland buffer line, it looks like,
Right before it, yes.
right before it.
Right. So is this new construction an extension of the three-season room?
No, the three-season room is part of the new construction. So there's a deck in a three-season room we're putting on the back.
This three-season room was not permitted either. I didn't understand that.
No, nothing was.
Okay. Mr. Carmichael, is the portion that we're looking at called existing deck, is that, did you say screened in, Mr. Carmichael?
Mr. Noel, again, Mr. Iafredi took care of this. I was not present on site, so I can't answer that.
Right. Is that screened in, Mr. Madden?
No, not as of yet, it's not.
Well, do you intend to screen it or to leave it as?
Yes. We're going to screen it, correct.
Okay. And then, Mr. Carmichael, do you know if the applications filed take care of what would be required aside from this problem?
So yes, we'll get sign-offs from conservation because it's near the wetlands, and then we'll ensure that it's built properly to 780 CMR.
I mean, that's quite
From this board.
the difficulty we have. It's not our purview, but obviously the way it's supposed to work is the owner goes to Mr. Carmichael's office and says, here's what I'd like to do, how do I build it? And then either has a professional answering along with Mr. Carmichael or knows what they're doing. I hope that this was constructed to Mr. Carmichael's code and requirements. We don't know that regardless of what we do tonight.
Mr. Noel,
Yes.
Chairman, so once we get past tonight, if we do get past tonight, we will go out and inspect and make sure that this meets all the requirements of the building code, and I will have Ms. Carlino sign off as for the implications to the wetlands.
So members, this is a situation that we've had more often than we like to see. That is a homeowner taking something on themselves and finding out after the fact or during the fact, during the process, that they've run afoul of zoning requirements. This doesn't present to me indication that the homeowner attempted this or had any reason to attempt this without coming to us first. Having said that, it's a big reduction. It's a 40% maybe reduction in the side yard setback, though we've heard from Mr. Shabbat, who lives next door and I think is into construction and building. Mr. Shabbat has no objection to this. So I leave it to members for questions or comment.
One question. What is the size of the deck and size of the screened-in porch? Is it on here? I just can't find it.
It is on the plan. Well, the total looks like more than 34 feet in width.
The deck is actually 16 by 16. And the screen porch is going to be 16 by 16.
Well, the plan, the RIM plan,
I'm going by.
Alan, says the deck that we're discussing is, it's hard to read, 18.8 by 17 point something. The structure that impinges on the side yard setback, if you want to separate that from the three-season room next to it.
I've got it now. I didn't see the detail in the top corner.
Okay, okay. Yeah, that's the detail I was reading from. You could blow it up to see the numbers a little better, but, I mean, this is the plan that we're going by.
So without this variance, the deck would just be much smaller, but the three-season porch would stay as constructed.
Well, without the variance, it would be an unpermitted construction, and he'd have to comply, take 12 feet off the 18-foot wide deck. It would be much of a, it would be a 6-foot deck extension on the three-season room if he were to, destroy this and try to comply. Correct. Or if he asks for a smaller variance, that's what's up to us. My point is, we don't like these. We don't like to see them coming before us because it's happened more than a few times in town. But if you remember, I think in the spring, we had one that there was some evidence that the homeowner kind of bulldozed ahead when there were indications that he perhaps should have known that he shouldn't be doing that. I'm not sure there's evidence of that in this case. That's an extenuating circumstance. That's all I'm raising. This is about a 40% reduction in the side yard setback. We have granted such reductions before. I just don't like the way this came about.
100%. If this was before us and nothing was built, I think we've already been moved on by now.
Well, David?
Yeah, I guess the only thing that makes it give me some comfort regarding the deck is that it's a deck and it's not a room. I'm assuming there's no foundation under this deck, little pillars.
What is there, Mr. Madden?
Just footings.
There is plan to screen it, however. There's no roof on it. What kind of roof would be on the screen?
There is a roof on it.
Not on the screen floor.
There's no, well, correct me if I'm wrong, but I don't believe there's a roof on the
deck. No, there's no roof on the deck. The roof is on the screen porch.
Well, okay, but the deck is going to be screened, so it has to have some roof structure.
No, the deck is a deck. The screen porch is the room.
Maybe I misunderstood. I had asked before if the deck was going to be screened, and I thought you said yes. That it's not the case.
The deck itself is not screened. It's just a deck.
And you did not plan to screen the deck?
No, I do not.
Okay, then I'm mistaken. My apologies.
Well, my mistake. I might have worded it wrong.
Okay. So your comment, David, I think stands that it's a deck.
It's a deck, yeah. And in reading, it's very hard to read this file, but how high off the ground is the deck? It doesn't seem smooth.
It's about 2.5 feet.
So it's not up like that.
And we've heard from the abutter that he does not mind this encroachment on the side yard setback. I would suggest that this is in line for a motion to approve, after our stern words of disappointment at how it came about. A couple of us have already said this wouldn't be a particular issue if it hadn't been constructed yet. I would suggest that a motion for approval is in order. It takes all three of us to vote for it. If somebody votes no, then it doesn't get approval, and then what happens is between the town and the homeowner.
Yeah, the fact that it's simply a deck and it's not a very high deck at that. Not an ideal situation, obviously, but I'm not opposed to considering a variance.
Is there a motion?
Make a motion to close the public hearing.
Mr. Noel, before you proceed with closing the public hearing, if I could add just one thing that might
Yes, certainly.
the tensions on the board. As the sun deck seems to be close to the lot line, you could include in your decision at no further time in the future that this sun deck be enclosed by another roof line or become habitable space. That would be my suggestion.
Thank you, Mr. Carmichael. I think that's a good suggestion. Any other comments or questions from the board? There's a motion to close the public hearing. Is there a second on that motion or no?
Second that.
Okay. All those in favor of closing the public hearing? Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
Yes.
Mr. Noel votes yes as well. I think Mr. Carmichael's suggestion was a good suggestion and in line with what our questions pertain to in the last few minutes. Is there a motion to approve the application for variance with the condition that the deck, variance shall not apply to any roof structure placed over the deck, fixed roof structure placed over the deck at any time?
I'll make that motion.
I will second that motion.
Okay. Any further discussion on that motion? All those in favor of that motion, which is to grant the variance, according to the plan of record, the plan of RIM Engineering of August 21, 2020, with the condition that the existing deck, that there be no roof, fixed roof addition over that existing deck at any time. Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
Yes.
I vote yes as well. All right, thank you, Mr. Madden. Again, good luck to you. It's not the way things are supposed to proceed, but I guess you know that more than anyone at this point.
Yeah, I learned a lesson.
Thank you, and thank you, Mr. Carmichael, for explaining, and let us know if there are other issues, but good luck to you, Mr. Madden. We'll have a decision for you shortly.
Thank you very much.
All right, thank you. Thank you, members, and thank you to those waiting. Sorry for the wait. That's what life is like right now. Where are we, Paul? Paul's not going to help. We're on 195 Mansfield Ave.
We're back on Mansfield.
Oh boy. This is the continued public hearing. I don't believe we need a motion to take it up because we continued the public hearing from the last public hearing. 40B comprehensive permit application for, I'm sorry, it's 195 Mansfield Ave, correct?
Correct. 195 Mansfield Ave.
Sorry, I'm looking at something else. Yeah. Looking at the minutes, which we still have to get to. 40B application. I see members of the applicant's party here. Again, thank you for bearing with us, and I apologize. Even though I thought we were going to continue three quick hearings, it didn't work out that way. It never does. Ms. Barrett, you are also here, correct?
Yes, I am.
Thank you very much for waiting. And where is our announcer and leader? Council?
Thank you, Mr. Chairman.
There you are. Mr. Freeman is here.
Yes.
Thank you. Where were we last time? I'll ask Mr. Freeman first, and what advance have we made since the last meeting? I'll add the same question of Paul to remind us of what we received in, but Mr. Freeman, go right ahead if you want to summarize first.
Sure. At the last hearing, we had presented our traffic report, and between the last hearing and now, your review from Gillen Associates, or Jack Gillen, I forget the company name, has come in, and we reviewed it, and our consultant, Scott Thornton, is here. We don't think he needs to present. I presume you'll hear from Mr. Gillen, and if there are any questions from our team, of course, we will hopefully be able to answer. The other thing we had done last time is we had reviewed the responses to various questions the board had raised previously, as per a conversation also that I had with Paul DiGiuseppe after that last hearing. And we submitted a letter from Brandon Cara to Preet Engineering that answered those questions. With Paul's advice, added a couple of waivers or explained some waiver requests. And we had stated last time, so there really is nothing new that we submitted. We had stated last time that mostly so we could see any other comments or proposed revisions to the plans. The main reason is that Conservation Commission was still before the Conservation Commission, and their peer review had not come in yet, and that has now come in, and it's manageable, but that consultant would like some additional things done, which I think include some studies in the field, tests of some kind, which Brandon Carr can explain. So we don't have the revised plans. In fact, one thing I forgot to mention is that you also heard the peer review from Pat Brennan, Amory Engineering, and there were some points there which are easily, complied with. Overall, it was, a good report. So those recommendations would be incorporated in our final plans that we would submit a little bit later. So really, that's where we are at, and I think that it's kind of traffic is the main thing tonight. Any questions you have, and maybe not tonight, but soon I think we would be ready to at least think about closing and drafting a decision.
Is Ms. Carlino not here? Conservation Commission not here?
I do not see her. She was notified.
Okay.
Of the meeting.
But I'm sorry, Mr. Freeman, are you saying you're waiting for something from Conservation at this point?
Well, I'll let Brandon amplify my answer, but we're not waiting for their peer review. Previously, we wanted to wait for it. It hadn't come in at the time of our zoning hearing, our last zoning hearing with you. And so it's now come in, and in fact, Brandon Carr, Decreed Engineering, is working on the revised plans. So, in terms of a next date, which obviously we'll figure out by the end of the meeting tonight, we will submit revised plans.
I'm sorry, Mr. Carr is with Decreed Engineering. Do we have a new report from Decreed? I don't have that in front of me.
No.
Peter, you want me to explain? So basically, good evening, everyone. Brandon Carr from Decreed Engineering. So we've been going through the Conservation Commission, process concurrently. We had a hearing. I think it was a week after our last EA hearing.
Right.
So they authorized the peer review. We've been going back, and we got that peer review last week. So basically, we were waiting to make any changes to get all the comments back, and then make the changes. And one of the comments is they'd like us to do a couple more soil tests on site. So we're scheduling that for about 2 weeks from now, and then we'll be revising everything at once, addressing Armory's comments, the board, planning staff's comments, and Concom all at once.
So you're responding to Amory Engineering?
Correct. And John Chesia Engineering is the consultant for the Concom that we're also responding to comments on.
But who is Amory? Is Amory the consultant for?
That's your peer review.
That's our board. That's the zoning boards.
Yeah.
Okay.
Correct.
So do we need to look at the Concom's consultants report, or is that's just very technical, I assume?
I would suggest we do. I haven't received it yet.
Oh, okay. So we don't have that. That's what I was getting at. I didn't know of anything after this. That was what I was asking. Okay.
I will get it.
Okay.
Tomorrow, and I will get it to you all.
Thank you. So, Mr. Carr, you don't have further info for us tonight?
No, we haven't made any changes.
Okay. That's fine. I understand. We'll just have to set our minds where we are in the process for that. It sounds like maybe the change skipped off the sprocket on our sprocket a little bit, but we'll get that report and then get your response to it. Hopefully the next time around, I guess.
Yes.
Amory Engineering. Is Amory represented tonight?
Pat's here. Yes.
Pat, thank you. Again, forgive me, the names are different on the screen than they are on the letterheads. Thank you. Patrick Brennan, yes, got it.
Yeah.
And this was from August 19. Did we talk about this at the last meeting at all?
We did. I went through the comments. If you recall, Mr. Chairman, one of the concerns was and I had looked into it and actually emailed you the following day, was about the increase in runoff to the reservoir, and what impact that actually was. And I believe the email that I sent to you was less than 0.03 of an inch would be the impact to the reservoir during a 100-year storm event. So it's essentially negligible. So
we didn't understand the volumes concerned. I remember discussing it that night, and we said, well, the runoff's going to flood the reservoir. And he kind of laughed, your engineers laughed and said, oh, no, it won't. And the email the next day, August 20, was the calculation is it would raise it 0.027 inches. So that's a small amount. It's a piece of paper or two, I think. So I understand now why that's considered negligible in the overall scope of things. Thank you for explaining it in those terms. Okay, so it sounds like we put this on the table for the next time. Unless members have any questions concerning conservation or these issues. No?
No questions.
Okay. What's next then, Peter?
I'll ask Bob, but as I mentioned, in the time between the last meeting or hearing, your peer review, Jack Gillen, on traffic, submitted that report, and I don't want to speak for him naturally. I believe he's here, but it was a good report. I'm not sure. I don't think we felt it called for any response, but I'm sure you would like to hear from him a summary. Although you do have it. It came in probably at least a week ago, if not 2 weeks.
Paul, is there someone here from Gillen and Associates?
Yes, Jack is here.
That is
Jack Gillen is here.
I had to turn off my mic. My microphone was off. I had to turn it back on.
List of names: Hollywood Squares 1 4, row 1, column 4. I don't know how this. Do these squares appear the same on everyone's computer? I have no idea.
You can choose to have the Hollywood Squares or just one large speaker.
I don't want to see anybody. I don't want to see anybody's large face, so I'm not going to ever do that. And please don't do it for us, because
you already told me once you would never unmute me again, but that remains to be seen.
You don't want to see my large face either, so please put the Hollywood Squares motif. But are the squares all the same? Mr. Gillen is row 1, column 4.
I think you see more than some of us do. Probably.
I don't have that.
Never mind. We'll ask Bill Gates to attend our next meeting, so he can explain maybe.
The way I see it, I'm row 1, column 1, so I'm happy with that.
All right. If you could just summarize, we have a letter dated September 1 from Gillen Associates. John Gillen is here. If you could quickly summarize for us what your findings or concerns were.
Yes, the traffic reports, as you know, are fairly thick. There's a lot of calculations. There's a lot of things we look at. We look at the trips. We look at the site distance. We look at the operation of intersections and all of that, and the driveway itself. And the proponent did a good job. They've been in business a long time, Vanessa Associates, and they did a good job. I'll expand it as the board wants things expanded, but the nutshell is this project does have traffic dispersed right away at the driveway, where a lot of traffic heads north and a lot heads south, and then they'll peel off a little bit, Freeman Street, they'll get down, and they'll split down at Route 123 and all of that. The report was written very well. The calculations were correct. The projections were correct. I can get into all of those, but there really weren't that many. 35 trips in the morning and 45 trips in the afternoon, and they dispersed quite rapidly. So there's no impact on residential local streets. The intersection that you had the proponent look at had been a problem since I was a kid, back in 123 and 140. And you were correct in assuming that was going to be a poor level of service, especially during the evening peak hour, which it was. And what I can see is that it's not this project that's going to have a significant impact on that intersection. It's just that intersection does handle a lot of traffic. But it appears to be a state-controlled intersection, And I would encourage the town to make their calculations and my response available to the state, Massachusetts Department of Transportation, and the local district office, so that perhaps they may want to put it on the tip for a state aid project down the line. And in the meantime, they may take those numbers and retime the traffic signals, so at least they'll be operating the best they can for now. But that, again, I don't see that on the as any sort of mitigation or linkage on this proponent. I just think making that information available is what I would really like to see. Now, moving away from the intersections into the sight distance, the proponent did a good job analyzing the stopping sight distance, and that they do have that coming out of the driveway. But when I looked at it, I understood what the proponent was saying, that the intersection sight distance is somewhat restricted by that large evergreen tree that is right in front of the site. But that's within the state right away. It's not on the proponent's property. If it were, I think the solution would be easy. We would just take the tree down and put another tree in 10 feet back on the proponent's property. But it's on the state highway layout, and it's growing up into the wires, the overhead wires right there, and you could really kill two birds with one stone if we could just move that tree back. And I know that the proponent said he's going to be meeting with the state anyways, because they want to talk with the state about changing the lane lines on the main street in front of the driveway, because there's a left turn slack going into Advanced Auto Parts right now, and on the northerly side, there's just paint like a gore area. Well, obviously, we start generating a lot of traffic coming out of the site. That traffic's going to want to go left across that gore area. There's going to be traffic want to come left into the site. It's going to be very confusing. So it would be very helpful if we could get a mirrored left turn slot, even though it doesn't have to be very long, to come into the site. That will also get a left turning traffic out of the through traffic, so that when they have when they have a golf tournament down there, or if they have something else someday, you're going to have a lot of through traffic on 140, and you'd like to be able to get the left turning traffic out of their way so that we're not introducing a lot of congestion. So I think that when they talk with the state about putting that left turn slot in there, even though it's not going to be very long, it will be quite effective. And it will also clear up any confusion that there might have been had you left the core area in place. So those are my findings. It's not going to be a major traffic generator. The site distance can be improved if they work with the state to move that tree back and put another tree at the prerogative of the town, whatever species the town would like to see. And obviously it wouldn't be something that would grow into the overhead wires, and also do that left turn slot. Now, I can elaborate a lot more than that, but I know we spent some time on some of the other projects.
Members, question for Mr. Gillen?
No question.
No, I don't have any questions. I don't know who can answer this. I guess I was curious. I mean, some of these ideas sound like good ideas, but giving it to state road, how likely is any of that to be actually accomplished?
Well, Scott.
Yeah.
We've had discussions with the state.
Hold on. I can't hear Mr. Thorne. There's a terrible feedback echo. Does anyone else hear that?
I do.
I have a problem hearing him as well.
Scott, do you have earphones next to the microphone or something?
That sounds better.
No, it's like very gravelly, and it's reverberating as if you're in an echo chamber at a high pitch. Try it. It's like there's feedback. You're feeding the signal through again or something. We can let's go on. Maybe there are instructions to call in by phone, aren't there, Paul? I think.
Yeah, I may have to do that.
Oh,
is that better?
Yes.
Okay. My apologies.
you put the earplugs in, and yeah, that's magic. You sounded like an old rock band, trying to sound, very, very deep.
Yeah.
No, go ahead.
So we have had those discussions with DOT, and we looked at making these types of modifications that Mr. Gillen had mentioned, and they were on board with it. We might have to do some repaving of 140 to make sure that the pavement markings go down on a nice fresh surface. And in terms of removing the tree that's just to the south to improve sight distance, it shouldn't be any issues. So we think that we'll be able to accommodate all the things that we're proposing and that Mr. Gillen has recommended.
Can you explain one thing or take me back? What is the left turn slot that is coming from 495 area to turn left into the development, into the project?
Yeah, so it's sort of it's a shadowing area in front of the Auto Park International driveway, which is and they have a dedicated left turn. And so what we would be doing is just sort of extending that shadowing area, that left turn, instead of having it as it is now, which is just an opening area to sort of protect the northbound left turns that are turning into the auto park. We'll extend it further to the north so that we have a left turn lane coming into the site. I think Mr. Gillen has his hand up as well.
Yeah, I'm trying to picture. You're talking about the extra lane as one goes to turn into, say, to McDonald's, correct?
Yes, but this is further north, up at the site driveway.
Right. So you're not saying you're going to extend it. Are you saying you're going to extend it or put a similar left turn lane in front?
It'll be a similar left turn lane.
Okay, not an extension of this one all the way.
Well, it's just a condition, a peculiarity of the way the roadway is configured in that section. You basically have 3 lanes as you're headed north. So
how you paint the lines, right?
Yes. Yeah.
Okay.
So then that center area, that's not a dedicated lane, but once you get north of the auto park driveway. So what we would do is just stripe it so that it becomes a dedicated left turn lane into the driveway.
Mr. Gillen? Oh, you're muted.
You're on mute.
I didn't turn the mic on. Okay, we have it now. I was just going to say, if it wouldn't be too much trouble, I think Scott may be willing to provide a small sketch showing how the left turn lane would operate into the site and then be transitioned back in the existing left turn lane into auto parts right now, and where the left turn lane is into McDonald's. Not a large plan, but just conceptually to show how they make use of that real estate that Scott's talking about in the middle of the roadway. And I think that if you showed how that's organized for the left turn into the site, the left turn into auto parts, and left turn into McDonald's, you can see how that real estate is multi-purpose for all the ways down there. It really isn't all that far. I don't know whether that's possible or not. I'm going to mute myself again.
Oh, no, thank you for following those rules so carefully. But I was just reaching for the plans. Is that drawn on the plans, the road plans right now, or no? The left turn slot.
I don't believe it is.
Okay, I didn't remember. That's why I was asking.
Yeah, but we can certainly add that, or put together a sketch and send it to the board.
Just a copy of whatever sheet is there now, showing us where the lane would come in exactly and that sort of thing. But you're saying the road is wide enough now? It's just restriping that would have to be done?
Yes.
Oh. Okay. Questions, board?
No. I think in general it's a great idea to put that in. So those are my biggest concerns was entering and getting out of the space around the development.
And then the other part of it was the increase to the ambush at 140 and 123 that we all face. And I think what I'm hearing is it's an increase, but it's negligible considering the problem that's already there. Is that fair? Mr. Gillen? Sorry, Mr. Gillen, is that fair? That it says it's a slight...
That's exactly what's going on down there, absolutely. And, you know, I'm glad the board looked at it because you can't ignore it, and you're not doing that. But I think by defining what is going on, I think that will help the state, at least, as I say, retime the signals. And if not, maybe there's a signal, maybe there's a phase that should be a recycle net that should be changed. I haven't analyzed it to that level, but I think that will be helpful. But you're correct. That's exactly what's going on. It's a nightmare right now, and it's not to have anything to do with this project. Thank you.
Your letter cites a standard of if it increases peak hour traffic by 5% or by 100 vehicles or more. That's a particular standard. And does this do that?
No, it does not. No, it does not.
Even at peak?
Even at peak.
Right.
But again, that's from the EIR guidelines and the state guidelines. And under the guidelines, this intersection being such a problem, it was a candidate to be studied. So you were correct in looking at it.
Yeah, and Mr. Chairman, just for perspective, the increase from the project at this intersection is about 0.7%, and so it's not in the realm of the 5% threshold.
Okay, thank you for pointing that out. I would like to see a sketch or drawing, computer graphic of that turn slot.
Yep.
That would be helpful.
I'll put that together.
Do you know, is the signal at 123 and 140, this is a little bit off topic, is that programmed to change at different times? It seems like the signal is longer during off periods or shorter during off periods. I'm not sure which way it is actually. Do we know that? The state of that traffic control system, or is it it's not camera operated at all, camera influenced, is it?
No, I believe it's sensor, and right now, because of the construction of the sewer project, they modified it to align with what's going on with the sewer project. But it's not a sophisticated timing system they have there, from what I know.
What kind of sensor, Paul? Do you know? Is it
in ground? I believe it's an in-ground system. But again, they've had to modify it because of all the work going on over there right now.
Just curious, because sometimes coming from Taunton on 140 at the post office, the line gets 0.7 of a mile long, goes all the way down to Barrow Street times. And that's the other direction, I realize, but I mean, the entire intersection's a problem. And coming from the project also at certain hours, after work, after 5 to 6:30, I know can get backed way up as well. But again, I guess this project is just only marginally going to add to that, so we really can't hold the project responsible. I guess that's how we're being advised to look at it.
And that's what Jack's study has confirmed from Scott's review, is that the thresholds that MassDOT has for project impacts were not exceeded.
John?
Yeah, thank you for recognizing me. As Scott knows, in the old days, a lot of times we had loops cut into the roadway, and they would have been cut up with any such a sewer project. And what that does is it sends the traffic signals automatically back to serving all roadways at longer cycle lengths and longer phases because they don't want to leave people behind. But as you've seen, a lot of intersections lately have video cameras.
Yeah.
They don't record signals. I mean, they don't record traffic. Well, some of them do. But most of them, they just recognize if there is demand or there's not a demand. And I'm not going to be long here. I'm just going to say, if there's no one coming on another street, you can gap it out and give that traffic back to the lane that demands the traffic. So with all the numbers that we've given you, both Scott and with the me confirming the operation, they're going to have the capacity calculations. They will be able to retime those signals, even if they don't put loops back in. They will be able to put the video detectors above, and the controller will not have to be changed. They will be able to use the existing controller to make it way more efficient than it is today.
It sounds like the problem is to be worked on elsewhere, not as part of this. Understood. Is there anything else in traffic, members, that we should discuss tonight? Any further? Go ahead.
Yeah, I just had, I was more of a process question, I guess.
What's that?
So some of these changes were.
Yeah, it is. Yeah.
Is that live or is that?
That's live.
Could you?
They're recording it though. It says it's being recorded. So.
I see somebody participate. Thank you. Microphone was just muted. Thank you. Go ahead, David. I don't know who was talking.
Oh, my voice is coming out as a female. I was like, what's going on? No, actually, it was just a process question. So we were talking about some of the improvements to the roadway in front of the site. Given that it's a state road, so we can put it on the plan and the application, but I guess I was just curious if the state at the end says, no, we're not going to do it for whatever reason. Like, how does that work? So, we could show it in the application, we would approve the application, it would show those enhancements, I assume. But how does that work when in reality, maybe the state would usurp us, if you will?
Yeah. Scott?
Yeah, so part of the reason that that Brandon Carr and I went to meet with the state was just to get their opinion on what was entailed with the project and what was being proposed. And at that point, if they were concerned about the proposal or some of the changes that we had identified, that would have been the point where they would have raised those questions and we would have dealt with them at that point. But really, they had some concerns about about emergency vehicle access, and some concerns about the radii for the driveway, which Brandon has incorporated, and that was about it. They had identified the change to 140 to put in the left turn lane, and that was really it. So we don't anticipate them, not agreeing to these changes that are being proposed.
Do they charge you for that, or did they just do it as an improvement to the road they own?
No, we do it.
You do it, oh, okay. And they give you the okay. Okay, I see.
But yeah, and thank you, Scott. I guess what I was getting at was, so it sounds like you've had these meetings and they've said, well, they think it's a great idea. Everyone seems on board, which is great. But I guess what I was getting at was, it's just at the last minute the state said, no, we're not going to do it for whatever reason. But does that impact the application in the sense that now you can't do those steps that you said you were going to do?
If we were to make it a condition, then it would, but
that's what I guess I was getting at.
If there was a critical feature that we said you must do this, for the I forgot what it was called, not Red Mill Village, maybe it was Red Mill. They had to widen the road, and that involved a lot of state cooperation, and we insisted they had to do that as part of the approval, but that was well underway. So if this is as important, we should talk about that and say we want it. We will insist that it be done. So let's see the sketch first and go from there, I think.
Yes, I agree. Like I said, it was more of a process question. I was just trying to understand.
Oh, it's a good question. Paul, did you have something? Sorry.
You stated what I was going to say.
The widening of that, of 123, yeah.
Well, in terms of it being a condition, if you chose to put it in there.
Yeah, okay. Is there, I see Deputy Chief Keene, is that, am I correct? And is the fire department here to add to our process?
Well, Chair, they are here. Deputy Chief Keene and Deputy Chief Robbins.
Okay. I see Deputy Robbins and Deputy Chief Keene. I'm sorry, I would have called earlier. I did not, not good at scanning everybody who's on the board. I would have called on you earlier to provide your input. Thank you for attending. The turn radius just came up, and that reminded me that we do need to hear from the fire department on that at least. But go ahead, Deputy Chief Keene. Have you reviewed these plans and you have comments or questions or suggestions?
Yes, we had talked about that before. And so the turning radius, they use our ladder truck, and they've done the study on that. The other concern was having a second entrance.
Yeah.
So, and I think that was just addressed that Mass DOT is looking at that.
Well, Mass DOT is looking at it in what way? Whether they'd be allowed to do that or whether they should do that? Sorry, I'm just not clear.
Well, I believe what I heard tonight is that if they can have if they can cut into the road for that second entrance.
Don't we have that emergency access as a second access, Brandon?
Yeah, so we are proposing that second access, that emergency access, and as Deputy Chief said, that'll be, since that's part of the right-of-way, that'll have to be reviewed with Mass DOT. We did discuss it with them when they met it. We met with them, and they said, yes, if it's properly designed, they'll allow it. So, I mean, and to back up to the point where if the town approves something and then we go to DOT and, they don't approve it or something, as part of the approval, we'll note and maybe request a letter or email from the fire department saying that, they want that entrance, and hopefully that'll, go somewhere with DOT as well. But, I mean, when we met with DOT, they were, they look favorable on the second entrance and the striping, so we anticipate that they'll approve it.
I guess just back to David Wren's process question. I mean, I think we're hearing that's important to the town, to the fire department, and to the town, so that we would probably, that would be a condition of our final, our decision. So I guess you should probably work on that to get whatever approvals you need.
I know Tom, Mr. Chairman, that the planning board might have a different, Paul might have a different opinion of that about whether we should have two entrances, but I think for the fire department, it's a necessity. The other issues that were addressed were the 20-foot access around the building, and I believe also they've already done the swept analysis from our ladder truck. We've talked about the fire department connection being within 100 feet of the hydrant, and I believe their proposal is to add the hydrant.
Okay. Thank you very much. If anything else comes up, please chime in and comment from the department's point of view. Thank you, Chief King. And Deputy Chief Robbins, excuse me, my voice is going, which is maybe a good thing. All right, where are we now with regard to what can be discussed tonight? Peter, are there any other issues? Or Judy?
I don't think we have any other issues, thanks.
I'm not aware of any.
But we have to move along on the conservation issues, on those related issues, and hopefully we'll be able to do that. Is there anybody else in attendance who wishes to speak to this tonight? Anybody from the public? Just for the record, I don't sense anybody. I don't see anybody or hear anybody. Always like to give that opportunity at these meetings. meetings every meeting if we can. So are we in line to continue this now, or Paul, did we need any other information to push this along from your view? Do we know if there's a difference from the planning board, by the way, Chief? The Chief mentioned that.
Certainly what Deputy Chief Keene is mentioning is an important thing, and obviously we want to make sure fire access is met. Deputy Chief Keene and I have had conversations before about pedestrian safety, that having, we're preferable if you have one entryway, it's safer crossing, but in this circumstance, you wouldn't be able to I don't know if it wouldn't, but it'd be a challenge to provide around the project access for the fire department with just one access point. So, to us, that wouldn't really be a significant issue here. This isn't a high frequency pedestrian area anyway, so it's more important that we get the fire department issues addressed. And then to answer your question, I think the biggest step going forward, we'll get the peer review from John Chesia, but the revised plans and that Peter mentioned, I think that'll be the step that really moves this thing much closer to the finish line.
Okay. Thank you, Paul. Members, any other questions or issues you want to raise right now? Or should we continue at this point to the October 14th meeting?
Mr. Chairman, I have no more questions.
Alan?
Mr. Chairman?
Yes, sir.
I would like to say that the applicant's been very responsive to any requests of the fire department, and they've been good to work with.
Very good. Thank you for saying so. We're glad to hear that. Is there anybody else from the town here who wishes to add comment? Okay. Is there a motion then to continue this, Peter, with your permission, to October 14?
That date works for me. If the rest of my team it works for, then that's great.
We think that'll work for for furthering this, for getting more information to us.
Sure. Yep.
Okay. Is there a motion, Alan or David, to continue this to October 14th? I'm forgetting what time we're at now, 7:05 or 7:10. I don't know what's on the agenda.
I'll make a motion to continue the public hearing to a comprehensive permit public hearing to October 14th at 7:10.
Whatever. 10 is fine. Alan, second. All those in favor? Mr. Wren, how do you vote on the continuance?
Favor.
Mr. Booley, how do you vote?
Yes.
And Mr. Noel votes yes as well. For the record, Mr. Tenore is not in attendance tonight. He had an unexpected work commitment that came up. We'll have to discuss, procedures for either re-involving him or going with the members who have been here for all the meetings now. But we can talk about that after. Okay. So this is continued to October 14th. Thank you to the participants, those we didn't talk to and those that we did. And thank you, Judy, as well. And let's keep Mr. Gillen, thank you. And let's keep exchanging the information fully so that we can hopefully move it along. Thank you.
Thank you very much.
Have a good night.
Great, thank you.
And the business meeting will continue. Judy, you're going to stay with us?
You don't need me anymore?
I was joking. I thought you'd say, no, I'm not staying with you.
Oh, no, I just wondered, do you need me? Because I'll stay. I mean,
no. Well, the next item on the agenda is the application of 253.
Yeah.
Mansfield Ave, Paul. There's been a request to continue, correct?
Correct. You'll see it. There was a request to the October meeting.
Yeah.
October 14th.
Yes, October 14th.
And do we know anything more about whether they are going to proceed in this venue or they're doing their alternative plan?
So I can give you an update because this is public, but this site was actually one of 5 applications we have received for marijuana retail establishment. So these 5 applicants are seeking the 2 host community agreements, which will allow them to go forward. So I'm part of a subcommittee that's reviewing these 5 applications, and we will be, we're estimated to be done with our review mid-October. So we will know, well, so then what happens there is the committee will make a recommendation. We'll score the applications, and then we will make a recommendation to the select board, who will ultimately choose the 2.
Why do we know it's 2, by the way?
Yes.
Why do we know it's 2?
It is because it's based on the number of liquor licenses for retail establishments, not restaurants and bars. So it's 20% of those. And so, and our bylaw does limit it to 2 at this point. Okay. So just retail. So if there's manufacturing, distribution, that sort of use, then there's no cap on that. But retail is obviously the most popular form of this type of business. So, so we have a couple of big events coming up, which the special town meeting, which was postponed because of rain at the end of August.
The rain that never arrived.
Yeah.
Oh, yeah, right. Well, so we are looking at either the special town meeting, I want to say September 26th, or the town moderator has the ability, September 26th at 9 a.m. And then the town moderator could decide to just put it on the October 17th fall town meeting, add the special town meeting to the fall town meeting. So, so anyway, at some point we will know if this property is even eligible to be eligible for marijuana retail, because remember, this is part of what the public will be voting on, is to see if this is part of the overlay district.
So it sounds like we're second choice. We're second on the list. The owner is going to proceed in that other direction if allowed to. So we're on hold, pending.
We're on hold until, essentially until, it's determined what the fate of that particular application is.
Okay. All right. Keep us informed as to the town meeting and all if you can. It was
absolutely.
It was confusing prior to the August date. I communicated with Paul. I couldn't even find the warrant on the town website. Maybe I just wasn't looking in the right place, but I had to ask Paul, do we not have a town meeting?
It wasn't on there, and apparently as a protocol it typically isn't. So, but we'll, once we get a firm, commitment, we'll let you know. October 17th is set. We'll see what the town moderator wants to do on the special town meeting.
You can keep us members and Judy informed on it, because it affects this application. It's just, which pile to put it in my office, the further pile or the closer pile.
Right. And also the zoning bylaw change for our village center. Corbett Allen was instrumental helping on the subcommittee almost a year ago now.
Yep. Thank you.
So we want to get that going.
Yep. This stuff is all related to us. I don't know how you can have a town meeting and not have it on the website, but okay.
I don't either.
I mean, I think it's required to post. Whatever. I'm not a lawyer.
Well, the town clerk does post a notice of it, and our communications officer does put that out on the town website, but it does not appear on the calendar. But I could be mistaken.
Wow. I think that was it. I think I looked on the calendar confirming that it was coming up, and I couldn't find it. I said, Paul, what's going on here? But
I can tell you, Tom, from social media, you were not the only one complaining about that.
Oh, okay. Thank you. I should be on that social media then. I don't hear what's going on in town. I sit here in my little cubicle in Providence. Providence. I'm not sure I'm supposed to tell you where I am. Is it an illegal meeting if I'm not in Norton? I don't know.
No, it's remote, so.
Right.
How remote is remote, Paul?
There is no geography on remote.
There is not. I'm going to ask Amy. I could do
It sounds like
that.
it sounds like it's not even remotely a problem. So.
Remote Rhode Island is such a far distance away, though, and it's it's Rhode Island, so anything can happen here.
I'm actually not far from you, Tom.
I know, Paul. Yeah. Anyway, other items. We don't have any bills and warrants, correct?
Correct.
But we do have 2 minutes that I had emailed this afternoon.
We didn't continue that yet. Did we?
Sorry?
Did we continue that?
I don't think you did.
Yes, we continued the 40B hearing. Oh, you're talking about 253? 253. You're right.
Voted.
Sorry, I think I hear Nicole. Maybe it's not Nicole. You're right. I think we should have a motion to continue the application for 40B at 253 Mansfield Ave to the October 14th meeting at 7:15.
I'll make that motion.
Thank you, Alan, for reminding us to be legal. David?
I'll second that motion.
No further discussion. Alan Booley, how do you vote on your own motion?
Yes.
Mr. Wren, how do you vote on Alan's motion?
I always agree with Alan.
Okay.
Yes.
I will, under that rule, I will also agree with Alan. I vote yes as well. So it is continued to October 14th. Judy, thank you. Now you can go and have a clear conscience. Thanks, Judy, for your help.
Nice to see all of you. See you again soon.
Sorry we kept you waiting.
It's fine. No, I was the one who had the messed up schedule. It's fine. See ya. Bye-bye.
Right. And Chris, thank you very much for your assistance, as always. We'll see what town council says on these couple of things, but thank you for your briefing us.
My pleasure, Mr. Chairman. Good night, everybody.
Good night.
Good night, Chris. And we're going to do, did you get the minutes, members, that I had emailed today? Did you get a chance to look at them? Or do you want to open them up now? It was for the June meeting. Apparently, I had never finished the June meeting and passed those out for approval. And then the second July meeting was the second group thing that I did. Does anyone have any comment on the June 17 meeting minutes as edited? If not, is there a motion for approval?
Make a motion to approve the June 17 minutes.
I will second that motion.
Okay. Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
Yes.
Mr. Noel votes yes as well. So June 17 is now done, Nicole. Yay. And that was my mistake. There was a hole there that I just hadn't come back to finish them, I guess. Next, the minutes of July 29, 2020. We had a couple meetings in between, but we had already done those minutes. Minutes of July 29, 2020, as edited, were distributed today. Just a few minor, edits and structural changes. If there are any changes, bring them forward. If not, is there a motion to approve them?
Make a motion to approve the July 29 minutes.
I'll second that motion.
Okay, any further discussion? None. Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
Yes.
Mr. Noel votes yes as well. Roll call vote taken. Okay, so we are up to date. I didn't do August. I didn't get to look at them. I intended to, but we're only that one behind now. The August minutes we'll get to at the next meeting, hopefully maybe the October 7 meeting. So thanks for scheduling that other meeting. I think it was a reasonable accommodation to make given the circumstance. And we'll try to keep that, fairly directed and short.
Two shorter meetings might be easier anyway in the long run.
Yeah, you're right. To separate the issues a little bit. You're right. And I'm going to try to get to Amy, Paul, please. And Nicole, remind me to make sure I get to Amy, we get to Amy, you get to Amy, somebody to ask her these specific things, and hopefully she can participate. Okay? Anything else, Paul?
I will send Jim the Mullen form and he'll have access to the video, so he can both. So he, will have the option of staying on for both the 195 Mansfield and the
other hearings.
One Great Woods.
Yeah, the other hearing that was continued. The Mullins form, it's a rule that you can, an absent member can listen or watch the meeting on recording and sign this form that he's done so, and then that member is still active on a matter. And it's smart on a 40B, obviously, to keep us all active because, next time, right, I get hit by a bus or David gets hit by a bus or, well, Alan wouldn't get hit by a bus. Then he would keep the bus at bay. But, we want to keep all the members eligible.
No one get hit by a bus. How's that?
No one's going to get hit by a bus.
And as you all probably know, you have on any one particular public hearing, you can only miss one meeting and view it and continue on. But if you miss a second, then the alternate has to come on.
That's why I'm here.
Well, I do want to let you know we may be getting an alternate, the other vacancy filled.
Oh, that's great. That's interesting. Can you say who's expressed interest, or is that not appropriate yet?
Probably not until the select board decides on it, but
it goes to them anyway in a public meeting.
Oh, you might be. Anyway, we'll leave the surprise what it might be.
I mean, I think I can give it away. It is on the agenda. And that's been posted.
Oh, it has. So what does it say?
It says to appoint Lucas.
Lucas,
as an alternate member.
He's back.
He's back.
Okay.
But he was joking that he said he'd only do it until until remote participation goes away.
Why? Because he likes being on camera? No.
I think he likes the flexibility of it.
Yeah. Gotcha.
That would be a great addition.
It would be helpful. We haven't had 5 members in all my years on the board. I don't think we've had 5. We're still a 3-member board until selectmen change that. But
well, no, you had 5 when David and I started. There were a while.
Lucas was still on.
Lucas was still on.
Did we? Okay.
But it was pretty short-lived.
Yeah. Okay. Yeah. I guess you're right. You both started at about the same time. Okay. So that is all. Is there a motion to adjourn?
Tom.
Uh-oh.
Before you do, can you just, one more reminder, I need the original reimbursement bills payable that I had sent you. Accounting will not take your signed one that you emailed me for Paul for his $9. He's struggling at lunchtime. He's very hungry. But you have to drop one off in that mailbox. They won't accept anything other than original in accounting.
Okay. Did I do that already?
You did, but you had emailed it to me. I never got the original.
I think I dropped that off as well. That's what I'm saying, but
may not have made it to me because I don't have it with anything. So I'm sorry.
I have it in my record, so I will either have the original at this pile over here, or I will reprint it and sign it again.
If you need a new one, I can send you a new one. But I'm sorry to bother you.
No, it's okay. It's okay. I just, it's fine. I want Paul to be able to eat, so. Remind me tomorrow, though, if I haven't done it, okay?
I'll shoot you a reminder. That's fine.
Nicole, thank you for your assistance as well. I'm sorry that you remained silent till the end.
No, it's no problem.
Believe me, it's a blessing. Oh, just kidding, Nicole.
You heard me all day. Paul knows I had a day.
Yeah. Anyway.
Let me not to linger, but do you go into town hall at all? Or Nicole, you do?
I do.
Yeah.
How many days a week?
I'm there Monday, Wednesdays, and Fridays. And then, if something has to get done, I've popped in for an hour and had the kids sit in the car. But I'm there 3 days for sure.
Paul, are you in-house or not at all?
I am.
Oh, okay. I didn't know that had changed.
Town hall is still closed to the public, but we will accept, appointments. But a lot of our work can be done by Zoom or phone call or email.
But I didn't even know, I don't remember when that change was made, when you started going in again. I didn't.
July.
Been a while, yeah.
It was July, but we still have some, there are times that, as staff would work because of the technology, we can work from home, but our manager has really asked us to start, has asked us to start coming in.
Okay.
On a day-to-day basis, but, some people have different, kids and daycare and so forth.
Sure. Okay, thanks.
Now,
Tom, I don't like it when you just walk in the back door, let me tell you. When the door's open.
Sorry, what?
I went to pick up one of the folders for the 40B before, and the back door was open, so I just walked in.
Oh, it didn't lock. Yeah, it did. When it's certain weather conditions, it won't shut.
To Paul's house or the town hall?
Town hall. I haven't gone to Paul's house yet. That'll be another time.
You're all welcome.
If Paul leaves the back door open, I'm going there for food on my way home.
So give us his $9, will you?
My check. My reimbursement.
I'll sign it. I promise. I'll drop off the original this time. I'll notarize it, Nicole, so they'll have no question.
Perfect. I want nothing less than that.
It's annoying that they don't accept, it's signature.
Well, I think accounting stuff, you know what I mean? I can understand why they would want originals. Other stuff, I think they're moving in a direction where they'll let us use the DocuSign or whatever it is.
I believe, because they do get audited every year, and but we do have the ability now to allow you to sign digitally.
But that's different. That's different than just scanning it. I just sign things and scan it.
Yeah.
The point is, if it's challenged, I then look at it and say, that's my signature or that's not my signature. So that's why it's just dumb to require originals now that scans are so good. But fine, I'm not trying to make Nicole, your job any harder. So
I actually tried to submit the one you sent me. I called her, I said, I have one. It's not the original, but it's like it's scanned. I printed it. And she said, nope, I need the original. So I tried, Tom. I did.
I believe you. If they slap cuffs on you, just to ask them.
I'll find you.
All right. Motion to adjourn?
So moved.
Second.
No further discussion. We are adjourned at, I'm sorry, Mr. Booley?
Yes.
Mr. Wren?
Yes.
Mr. Noel, yes. We are adjourned at 9:13. Thank you.